what was the basis for dropping him to the ground, according to your words. Did we just see your fist ball up and strike Mr. Crawford?
Yes.
A cop's worst nightmare is a judge who doesn't care about professional courtesy, just like this cop who got grilled in cross-examination.
How would you describe what you see here in Mr. Crawford's face?
On July 7, 2019, Teddy Sims, a Bayton police officer, was accused of aggravated assault when he made a wrongful arrest of Kendrick Crawford. After that, we got to witness one of the best cross-witness examinations during his deposition.
Don't call nobody up here, they'll go to jail.
Call nobody up here.
Yeah, say, hey, I'm over here, come over here, because people will go to jail.
Hello?
Mr. Sims?
Yes, ma'am.
Why did you tell Mr. Crawford that if anybody came up there that they would be going to jail?
Because a lot of your scenes, they can range from car accidents to burglary scenes, you name it. A lot of people will come up and they'll start to interfere. They'll start to create chaos, and that could lead to situations where people may go to jail.
So you weren't telling the truth when you said if they for simply coming up there, they would go to jail, right?
Objection. No, it's just implying, like, hey, if they come up here, they're going to go to jail.
Yeah, I heard you.
Right.
So that wasn't true, right?
Objection. Not necessarily. If somebody was to come up there and, break a law, they would be going to jail.
I'm being harassed by officers. They got me,
Harassed.
For some reason, I don't know what's going on. I got driver license, insurance, everything. And
yeah, man.
Sir, I told me to search my car. What's going on? I don't understand.
What do you mean? I searched it. Yeah, you go ahead and search. That's what's going on right now.
I don't understand.
What do you not understand, sir?
Maybe he should have told him why he was searching the car. What was suspicious about him? Did he commit a crime? Was he suspected of committing a crime? This was, as Mr. Crawford said, pure harassment.
So when am I free to go?
Whenever, man.
Whenever?
Yeah. All right, put your money back.
Mr. Crawford never left, even though you told him he can leave whenever he wanted to, right? He never made any moves to leave, did he?
At this, no.
In fact, the first thing that occurred was you grabbed him, right?
Right.
You didn't tell him why, correct?
Correct.
And did you even know why?
Yes.
Why?
That Officer Surratt had either reasonable suspicion for detention, or probable cause for an arrest and or search.
Okay. Can you tell us why? Can you explain why you felt the need to threaten force when you were simply trying to detain Mr. Crawford to search him?
Absolutely. So, there's times in the street when dealing with resistant suspects, or even just suspects that appear to be compliant, where, and you can't see in this video, but he was tensing up his muscles.
Mm-hmm.
So I am telling him, hey, I'm communicating with him, hey, do not do that, or there's going to be consequences. And the reason why is the suspect can take off running, suspect can then start fighting, or just a number of things. So I was letting him know, hey, quit tensing up, I'm going to freaking drop you.
Right from the get-go, we can see that Kendrick's attorney, Amika Lewis, wasn't pulling any punches. Sims was about to be grilled so much more as this interview went on.
And it's you that's tasing him, right?
Yes.
Why are you tasing him?
Because due to his resistance, me grabbing him wasn't working. Me holding him down wasn't working. Nothing was working at this point. Now I have to worry about, he has one handcuff on, which can be used as a weapon.
Mm-hmm.
But at this point, I'm just trying to gain control of him.
But that was your choice, right? Not to put the handcuff on him, but actually to take his arm that you could have put the handcuff on and throw him to the ground, right?
Correct.
Don't tense up, dude. Oh, freaking drop you.
You told him not to tense up, dude. I will freaking drop you, correct?
Correct.
And so when you say don't tense up, I will freaking drop you, that indicates that he had not tensed up, right? That you were warning him not to. You didn't tell him stop tensing up. In other words, you said, okay. Did we just see your fist ball up and strike Mr. Crawford?
Yes.
And he's still begging you to please stop, correct?
Correct.
He says, you're killing me, isn't he?
Yes.
He's not cursing at you?
No.
He's not being rude towards you?
He's being resistive. He is not putting his hands behind his back like we wanted from the start of this encounter. He's not complying. He's resisting. He's physically resisting.
Okay, that doesn't answer my question. I asked you, was he being rude to you?
Rude? No.
What do you see? What's going on? I don't have anything. What's going on? I'm taking the bed off.
This was nothing more than police brutality. The cops didn't announce they were going to handcuff him. They didn't declare why. They just threw him to the ground, and then Sims punched and tased him like some barbarians.
Give me your other arm. Put it behind your back.
Okay. Do you still agree that it was on his chest? Not his neck?
It was definitely like upper close to his neck. It's really hard to tell on this video. But yes, I mean, it was right there under his chin.
I want to actually slow this down a little bit because I want you to tell me where your actual body is and as it relates to your legs. Your body's on top of Mr. Crawford's body and your legs wrapped around it. Isn't that true?
It appears, yeah. I have one leg wrapped around his waist.
Okay. And your arm is around his upper chest neck area, correct?
Correct.
And you're asking him at the same time to put his hands behind his back that you are on top of, correct?
At this point, I believe we're just trying to transition and put him on the ground.
Is holding Mr. Crawford from behind?
Yes.
And again, you're choking him, right?
At this point, I believe I'm just securing his head. I don't think at this point I'm actually choking him.
At any point were you choking him?
Not really intentionally. I was just kind of pulling up on him just to try to do something to gain control of Mr. Crawford.
Okay, and we see all this blood on his face, right? Bubbles of blood all over his forehead, okay. Correct?
Right.
Is that you saying you want to go night-night? You want to go night-night?
Yes.
Why are you saying that?
At this time, adrenaline was going. I'm hurt. I'm tired. In the fight, I was just telling Mr. Crawford, like, hey, like, stop your actions.
Apart from completely abusing the guy, this sick human decides to taunt the man. Can citizens trust cops after seeing something like this? Definitely not.
Put your hands behind your back.
Put your hands behind your back.
And again, you're asking him to put his hands behind his back while you're straddling his back and choking him around the neck. Isn't that true?
As far as choking, I wasn't trying to incapacitate him. I was like applying pressure, just pulling on something to make work. Yes, we wanted his hands at least close to behind his back at this point, so we can at least get him into somewhat control to handcuff him.
Hey, bro, stop! Man, you're fucked up enough. Alright, I got this arm. Get up. Get close. There we go.
Is there a reason why you didn't watch the videos if they were made available to you, or your report before being subjected to this examination by me?
As I say within the previous hour, no, there's not a reason.
The real reason he didn't watch the video is that this guy knew he messed up. No amount of footage review would have saved his face from all the horrible human rights violations he committed.
Can you see Mr. Crawford's face here?
Yes, ma'am.
You see all the blood over it?
Due to the lighting, not really. I do see something on his face. I do see swelling. I really can't see blood from this angle.
What about now?
Yes, ma'am. No, I can't.
How would you describe what you see here in Mr. Crawford's face?
I see an individual with blood on his face.
Would you say a minimal amount of blood?
It's not the most I've ever seen, but it's not just a small cut.
But we can agree now that Mr. Crawford's, from what you see there, Mr. Crawford's injuries were not minor, correct?
Minor as in he's not incapacitated, he's not in a coma as far as major, but minor as in a couple scratches. No.
Would you consider fractured orbital sockets to be minor?
I wouldn't consider it to be minor or major. I mean, I'm not a doctor. It's really hard for me to go into detail about that.
So basically what you see of Mr. Crawford's face is kind of business as usual, huh?
No.
The attorney discussed these injuries because hero cop Sims here wrote Kendrick's injuries as minor in his report. He was so unfazed by the beating he gave the poor man.
Instead of putting unknown or I wasn't aware or things were moving fast or anything like that, you actually indicated the description here, correct?
So those were like some pre-filled tabs on the software on the report. To the best of my knowledge, there's like minor visible injury. There's life-threatening injury, such as someone's in the coma or such, and then there's death. So that's why I chose the minor visible injury. It does not give me that option. So unless things have changed since I've done the report.
All right, so the superficial wounds to the face, that was already automatically just a drop-down choice that you have. You couldn't fill that out yourself, right? Is it true that you stated that you don't feel that it's a punishment because you didn't want to be a law enforcement officer anymore anyway?
I've never stated that.
So your lawyer was being untruthful when he stated that to the media, correct?
I'm not sure my attorney even stated that. It's something we haven't discussed, and this is the first I've heard of it.
So you didn't see any article in that regard that said that you didn't feel it was a punishment and you were no longer... Well, let me just ask you, is it true? Do you feel that it wasn't a punishment?
The punishment was going through the investigation, the mental anguish, and everything led up to that, me having to change careers. All that itself was a punishment. The going through the court process, the indictment, that is punishment.
Changing careers and mental anguish was a punishment to this guy. What about the torture he inflicted on a defenseless civilian for no reason?
And at the end of the day, the person who you stopped, ultimately, Mr. Crawford, was not committing any crime.
Initially, at the stop, before the stop, no.
You're the criminal here, right? You were the one who were indicted. You were the one who was indicted, and there was probable cause to find that you, in fact, violated the law, correct?
Ma'am, I want to answer your questions.
My question's there. You can answer it.
No, I'm not a criminal.
So your indictment by a grand jury finding there was probable cause that you assaulted Mr. Crawford to the level of a felony, that meant nothing, right?
No, it meant a group of individuals found probable cause, and that indictment was later dismissed.
Well, it was dismissed because you entered into a plea deal and you gave up your law enforcement license that you worked very, very hard for. You had to give up your entire career for, correct?
Correct.
One case took over the world, and its cross-examination was harsh as well.
You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd.
Courtrooms are places where you see cops in their most miserable states. Their actions finally catch up to them, and now it's time for the consequences. Starting off with the cross-examination of the officer involved in George Floyd's death.
You were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man, I don't want to get shot," right?
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Fallen, yes.
And then the other officer with you on the other side of the vehicle changed that to put your hands on your head, correct?
That's correct.
They did all that and didn't investigate anything. Humanity and basic human decency were not in these cops' dictionaries.
Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was talking to you, he was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
She's asking these questions to make it clear that Floyd wasn't drunk, sick, or had medical issues. While he was talking to them meant that he was sane and posed no threat.
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
You were asked some questions about what the other officers were doing, correct?
That's correct.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Thank you. Nothing further.
Basically, two officers at the scene gave two different commands to Floyd, hands on the dash and hands on the head. He can only do one, so they used this trap to drag him out. Eventually, this cop was sentenced to 21 years in prison. This officer certainly earned his karma, but things took a bizarre turn when this next cop's qualified immunity was revoked.
He had nothing in his hands, and he was shot twice and killed.
A routine traffic stop in 2011 ended tragically when Officer Osvaldo Vela Rial fatally shot Benny Herrera, an innocent man. Years later, Herrera's family sued the officer, and this video documents a pre-trial hearing related to that lawsuit.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shooting man in seconds? Cops these days really don't have the guts to investigate. They are so scared out of their minds, everything seems like a threat.
His camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
And to top it all off, his PD cleared him of any wrongdoings. The system does support corrupt pigs, or else this one should have been fired that exact day.
Before he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make
Well, don't
that
we have to view our, view this in the light most favorable to the plaintiff here. I mean, and so if we do what you just said right now, offer two possibilities.
The body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Vela Rial's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Vela Rial had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Vela Rial got off easy, basically. No real reason for the shooting, but he's still on the force. Go figure.
It seems like he had a better vantage point possibly than Mr. Vela Rial.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Vela Rial fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And right. they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
But this tyranny wouldn't last long because the expectations of the victim's family were high.
As long as the historic facts are undisputed, the question of whether or not Officer Vela Rial's actions were reasonable is a question of law. It's not a question that you give to a jury because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, if we take those facts, you're saying that as a matter of law, Officer Vela, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Vela Rial knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Vela Rial knew with respect to whether he was armed?
We know that dispatch told Officer Vela Rial and Officer Miali that Mr. Herrera was not known to be armed. But that's not the same thing as saying he wasn't armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense tried everything, but the judges weren't having it. At least he didn't plead insanity like all the other cops do.
Here, the domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
Fully on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
And both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Rial opened fire, Mr. Herrera rapidly removed his hand, and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The cop had no need to escalate the situation. He could have just taken a chill pill and relaxed himself and the people he was supposed to investigate.
Opposing counsel is that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Both hands were visible, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
No matter what the defense argued, the facts were clear. Herrera was dead, and Officer Vela Rial was responsible for his death.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless they're punitives. If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
at that point, I got the answer. Right.
Finally, some justice for Herrera. Officer Vela Rial's qualified immunity was revoked and a trial took place. The court ruled that he had used unlawful deadly force. The city also paid Herrera's family $1.4 million in compensation as the case proceeded to trial. This next sorry cop was also being questioned for excessive force.
Did you apprehend good guys?
Detective for him.
Never. I take that back. I bit a victim one time because she jumped in front of me.
Do these cops not have any trigger discipline? Daytona Beach PD officer Joshua Mercer was in a gunfight with Marvin Jones. Jones got hit 5 times, and his girlfriend, Aviana Bailey, got caught in the crossfire. She's paralyzed from the chest down now, so she's suing.
Playing, fumbling, doing something in his lap. There's none of this, there's none of this, it's this. And he's looking at me the whole time. And then it happens.
What happens?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my... So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving...
Exactly.
I'm sorry. If I'm driving... The driver's side the door is here, so he did this.
Okay, because you had him moving.
Excuse me.
Further into the passenger compartment.
No, that was completely.
Right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight. All of his memory issues are going to pop up right now.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No, okay. I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area. right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least one, and possibly two. I can't count them. I can't tell you how many exactly I saw.
The man shot a guy 5 times and sat there like he was at a coffee date with his friend. He showed 0 signs of remorse.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. Fired at you, or you saw several muzzle flashes?
Yes.
Okay. How do you define several?
Objective form.
1 or 2. 2 probably.
Okay. Several's not 1.
Yeah.
We agree to that. Do you mean is several more than 2?
Objective form.
I would say 2.
Okay.
So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of the serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? That's what we say. Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Objective form.
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his actions, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective form.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
Okay.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
If you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
This cop was downright dirty and arrogant. These are exactly the kind of people you don't want on the force.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Why does that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
protect you for him?
Never. I take that back. I bet a victim one time because she jumped in front of me. So I did. I bet a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
There was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
The one of them.
The one of them had a felony warrant.
The guilty one, not the
yes.
innocent one.
So the mother's there, and we got the place surrounded, and basically she said, "You're not coming in." Well, he's in there. We can see him in there. We can force entry on a felony warrant. I eat that one. That was my responsibility all day long, for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut.
Did you ever arrest a good guy? Form.
Did I ever arrest a good guy?
Yeah.
This next judge didn't spare the officer any kind words.
It's up to the court. I can get arrested? Yes, it's up to the court.
Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers.
There's no better feeling to see some justice being served in the court, and what's even better is when it's being served to corrupt police officers. The second case saw the officer's life flash before his eyes when he realized what a mistake he made. But before we get to that, the atmosphere in this courtroom took a serious turn when the judge started to narrate what happened to the victim. On January 28, 2015, ex-cop William Melendez's traffic stop of Floyd Dent escalated dramatically. Court proceedings later revealed shocking details of the incident.
January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenuski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head. In his attempt to arrest him, he was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten.
As the judge recounted the events, the officers' actions became increasingly disturbing. The aftermath of their conduct was particularly appalling.
The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. in disbelief of what had occurred to him. What crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking to do a nigger. As police officer John Zelenowski, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up right now. LOL."
What makes the situation bad is that the officers had no shame in what they did. They were actually enjoying their gruesome acts openly.
How does this happen? On January 28, 2015, you did not fulfill your job. You performed Just Us, a game that began with a police stop. The purpose of it was to harass and degrade a motorist in Inkster, the man chosen for your game. Let's follow a car in a known drug area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a gun or drugs in a vehicle. Upon stopping Mr. Dent, you knew, and upon stopping Mr. Dent, who was dead wrong for driving with no license or license suspended, running stop signs, and weaving in and out of the back street, which the court saw on the video. Upon being stopped, Mr. Dent put his hands out of the driver's window in plain view. Your partner and you pulled him out. When he didn't move fast enough for you, you refer to it as resisting. I call it bowing down to your command. You utilized your dirty, hairy tactics and used excessive force to arrest him. Your job was twofold: investigate the situation, be a positive example to Officer Zelenowski, kicking and tasing and ultimately throwing Mr. Dent into a windshield of a police car with a dash cam, which I refer to as the eye of justice. You were so into your bravado that you forgot the eye of justice was watching you and recording this disgusting beating, seeing Mr. Dent slammed into the window shield with blood running down his face.
This was also a hate crime because of the text messages exchanged. Racism is still pretty much alive in our police system to this day.
Fist busting after taking him down as a sign of bravery was just another cowardly act caught by the eye of justice. You knew better. You were better trained than any of those officers out there. You were more experienced. It took me several days to read the letters that people sent talking about your character, about the man that you are. 3 of those letters, I believe, were from African Americans, and one even professed to be like a mother. One or two things: either they're all racist or there's something redeeming about you that somehow in some way you forgot that night. The way you denigrated that man was awful. Who would know and who would care about a lone black man being assaulted by upstanding police officers? Boy, were you wrong.
We need more judges like her in our country today. She fearlessly stated the obvious and courageously addressed all the issues that everyone else was avoiding.
The other eye of justice captured you and your posse making fun of Mr. Dent, mimicking him struggling while you all wiped the blood off your uniforms with disinfectant while he watched. Such an awesome, caring, properly trained police officer. You led your fellow officers down a path of cowardly behavior. But today you will pay for it. There's an old saying, it ain't no fun when the rabbit's got the gun. It's equally applicable when he has the video. The eye of justice in this case. You betrayed your city. You caused your lovely wife heartache. And you caused Mr. Dent severe anguish. And finally, in the words of Vicky Yost, your commander, accountability is required to ensure continued community trust and healing.
Following a long verbal lashing, the judge ultimately handed down a punishment to Melendez, and his response is truly worth watching.
Only you and God can change your character. I've had an opportunity to listen to both sides. And I had to say this because I didn't say this during the trial. But it was my privilege to be able to oversee this trial because I had great lawyers, and great lawyers make jobs real easy. I am going to commit you to the Michigan Department of Corrections. However, after weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. Of course, it's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
Although some might argue that the punishment was not enough, it's still a win that the officer had to serve time and that he won't be on the force afterwards. Next up, we have the court hearing of Shawn Paul Reyes versus the state of Connecticut. Shawn sued the officers after he was taunted out of a public building.
Reyes circled around me and did not give me his name or accept the department card. As he headed up the stairwell, I thought in the best of City Hall, I keep him around and prevent him from going upstairs. He kept coming toe-to-toe with me. I extended my arms to prevent him from going to the second floor. Okay.
This is what it is.
If you want to, yeah. All right, do me a favor, we're not done yet. Sit. Where's the pen? You got your pen?
Yeah.
Okay. I'm going to submit a warrant. I'm going to review the camera footage, right?
Yeah.
I'm going to get his statement. I got his statement, your statement, and the camera footage.
Yeah.
I'm going to put that all in a report.
Yeah.
I'm going to review it.
Yeah.
If I have probable cause to believe that your actions rose to the level of, I would call it an assault, since luckily he admitted to me that he was not injured and he did not want medical attention.
Yeah.
Although an impairment of, injury, according to definition, is impairment of physical condition. So I'm not going to do it to you.
Yeah, but I mean, I didn't.
I know it doesn't matter. If you push somebody, I'm not going to do it to you because I don't want to assault you. But if you impaired somebody's physical condition,
like that. I just kind of put my hands up.
Well, okay. So, however, if I think it rose to the level of a discon, I'll submit warrants, maybe even for both of you. If some of his language is to the point where it's disruptive. Then I'll submit a warrant for both of you, and we'll see what and then it's up to the court.
So you told me I could get arrested?
Yes, it's up to the court. You got physical with somebody that, for the most part, you really had no reason to be physical with.
I didn't want him going.
Because he was filming.
Upstairs.
I know, but for what? For what? He's filming. What is he doing? Why can't he go upstairs? It's a public building. It's City Hall, for Christ's sake.
Like I said, if I was given those forms,
you know.
Shawn doesn't use any disruptive language and remains respectful. I'm sure you've seen us review multiple videos of his audits. The real deal is how physical the officer got.
After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me. That's exactly what happened.
Right. That didn't happen to you, right?
Oh, no, it did.
It did?
Yep.
Okay. And the incident at the library that you're talking about, the videos, you're talking about the videos involving, I think it's Tippett and other, and the statement that if he'd done something 20 years ago, he would have been dead in the back of somebody's trunk.
Objection is what? 20 years ago, that would be dead. His teeth would be missing.
I'd have removed his teeth. He would be dead.
This is not going to end well with you, you know that.
Okay, we'll see.
So the cop was worried that Shawn's video would cast him in a bad light by referring to a library video where a cop gave him death threats.
Relevance, hearsay, outside the scope of arrest.
Sustain. Keep going.
Okay. The incident at the library, were you familiar with what happened there?
Objection, same, all three grounds.
Keep her out of that, Judge.
There's been some discussion in the trial thus far about the incident at the library. That's this question.
And that involved Danbury Police Department police officers, right?
The incident, I'm sorry.
At the library, sir?
Yes, it did.
And you're familiar with the library incident, right?
Yes.
And are you familiar that Mr. Reyes made a complaint about Danbury police officers in that case?
Objection, relevance.
I want to allow it as...
At the time of this...
Okay, here's how it's going to work. He's going to ask a question. Okay. He may object. I rule in the objection. You don't answer until I rule in the objection. Got it. It's going to be easier for everyone. And that's partially on me because I fall. So let's try that again. Ask the question and answer and see.
These two incidents had totally different levels of intensity. The defense, in this case the state, was trying their best not to have the other Danbury officers be included in this hearing because their statements were beyond inhumane. But the judge was annoyed by their interruptions.
At what point?
At any point.
I received a couple on my work voicemail, but I just didn't.
Did you put that in the police report somewhere?
Well, I was threatened after the fact.
Well, threats are important, aren't they?
It depends if you feel threatened or not, and I didn't feel threatened by them. I just deleted them. They were on my work voicemail.
So you didn't feel threatened about what people had said, correct?
Objection, pass the next one.
I'll allow him to answer his question. Objection overruled.
It's a tough thing. I can threaten you right now. It all depends how you feel about it. I would hope that, you wouldn't feel threatened by me, but so at the time, I just deleted those messages. I don't remember if I felt threatened or not, but I didn't want to, I just deleted it. It was only a couple. It wasn't like the other people other officers.
This cop was just bluffing. Threats are no joke, and those threats could have been substantial evidence against Shawn in this case, but they weren't real to begin with.
Approach. Off the record. Approach.
Mr. Reyes arrested? Is that what you did?
I would object because that mischaracterizes the testimony. He said he had a question morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question,
sir.
Everything Shawn's lawyer said raised an objection. Were all of his actions irrelevant? The defense didn't have any points of their own, so it seemed like they only wanted to disrupt Shawn's attorney. The judge was getting furious.
You weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection, ask the answer.
Sustained. We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can.
Rejection.
Nope.
That's the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
The judge was furious. He ordered both the lawyers into his chambers, and we can faintly hear how his mood was. The state's attorney's objections were so annoying that the judge had to personally give him an earful. The fact that the judge hasn't put a stop to this waste of taxpayer money speaks volumes about the level of corruption we're looking at here. And that's all for today. If you'd like to see more court hearings of officers being grilled, let me know in the comments below. If you liked the video, subscribe so you don't miss out on the next one. And make sure to check out this one too.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided you're going to make sure this is cut and dried, and the way you're going to do it is to make sure that she's